Welcome back to the deep dive. Today, we're diving headfirst into something really critical for any HR pro aiming for the top: U.S. employment laws and compliance. This isn't just about, passing an exam. It's about understanding the very foundation of fair and effective workplaces. Our mission here is to, well, cut through the legal jargon, zero in on the core insights, and make sure this vital information sticks for your SPHR exam and, more importantly, for your career.
Yeah, it's truly a cornerstone. Navigating these laws strategically means not just safeguarding the organization from risk, but also fostering a truly equitable and productive environment for employees. We'll pinpoint the key federal statutes, clarify critical terms, and walk through their real-world implications, all while giving you those memorable SPHR-style insights and memory triggers.
Exactly. Think of this as your personalized roadmap to mastering the scope, the protected classes, employer obligations, and those tricky areas that often trip people up. We're covering everything from Title VII's anti-discrimination principles to FMLA's leave protections, including things like adverse impact calculations and best practices. So if you're ready to really understand employment law, let's get into it. Okay, so when we talk about anti-discrimination law in the U.S., one statute stands as the absolute bedrock: Title VII of the Civil Rights Act of 1964. Where do we even begin with its significance?
Well, its significance is foundational indeed. Title VII prohibits employment discrimination based on race, color, religion, sex, or national origin. Those five categories are your core protected classes. It's broad, applying to employers with 15 or more employees, including part-time staff.
15 or more, okay.
Right, and it touches every single aspect of employment, from hiring and firing to pay, promotions, training, even the everyday work environment. The clear mandate is that you cannot take an adverse employment action because someone belonged to one of these groups. Simple as that, really.
And Title VII gives rise to two distinct legal theories for discrimination, often with, well, very different implications. Can you walk us through disparate treatment versus disparate impact? Which one do HR leaders maybe miss more often?
Yeah, this is where the nuance really comes in. Disparate treatment is about intentional discrimination. Think of it as direct, overt bias, like explicitly rejecting a female applicant because she's a woman. The intent to discriminate is key there.
Right, intentional.
But disparate impact, however, is far more subtle and, frankly, probably the one HR often overlooks. It occurs when a seemingly neutral policy or practice, like maybe requiring a certain physical height or a specific score on an aptitude test, disproportionately disadvantages a protected group in practice, even if there was absolutely no intent to discriminate.
So if a policy causes an adverse impact unintentionally, how does an employer defend against that kind of claim? What's the standard?
Okay, so the employer must demonstrate that the requirement is truly job-related and consistent with business necessity. And that's not, a low bar.
Right.
A practical HR metric we use to flag potential disparate impact is the 80% rule, or 4/5 rule.
The 4/5 rule, right.
Exactly. If the selection rate for a protected group is less than 80% of the rate for the highest performing group, it triggers a review. So, for example, if 20% of male applicants get hired, but only 14% of female applicants do, well, that 0.14 divided by 0.20 is 70%. That's a red flag. It demands a closer look.
Beyond direct discrimination, Title VII also strongly addresses the more insidious issues of harassment and, critically, how we protect those brave enough to speak up. Tell us about those anti-retaliation provisions.
Absolutely. Harassment, whether it creates a hostile work environment or involves quid pro quo demands, is explicitly outlawed. But the anti-retaliation provision is equally crucial, maybe even more so in practice. It outlaws punishing anyone who complains of discrimination or participates in an investigation. HR's strategic role here isn't just about processing complaints. It's about ensuring there's a clear, safe reporting environment where employees feel empowered, not intimidated.
Right, creating that psychological safety.
Precisely.
So for our SPHR learners, what are the core compliance strategies that really embody the spirit of Title VII, beyond just ticking boxes?
Well, the core insight for Title VII compliance isn't just checking boxes. It's about embedding a culture of objective fairness. Think of it as building bias-proof processes. Using structured interviews reduces subjective hiring.
Right, more objective criteria.
Exactly. Tracking applicant data proactively reveals subtle disparities before they potentially become lawsuits. And consistent manager training ensures everyone understands not just what to do, but why it matters for a legally sound and equitable workplace. And just to remind folks, the employer under Title VII is anyone engaged in an industry affecting commerce with 15 or more employees for 20-plus weeks a year.
Good reminder. What are some of the pitfalls or common exam confusions for Title VII? Where do SPHR candidates often get tripped up?
Okay, common traps. First, don't assume only customers can sue. Employees and applicants are fully protected. That's a big one.
Hmm.
Discrimination isn't limited to just hiring and firing. It includes pay, assignments, benefits, training, the whole life cycle.
Hmm.
Also, reverse discrimination claims, while sometimes politically charged, are also covered by Title VII.
Okay.
And critically, remember that sex under Title VII now broadly includes pregnancy, sexual orientation, and gender identity. That's evolved. Finally, the BFOQ, bona fide occupational qualification, it's a very, very narrow exception. It requires strict business necessity, not just, convenience or preference.
Got it. Super narrow. So how can our listeners effectively remember Title VII's core protected classes? Any mnemonics?
Yeah, for Title VII, you really need to engrave these 5 into your memory: race, color, religion, sex, national origin. Maybe think of it like RCRSN. Race, color, religion, sex, national origin. Those are your foundational protected classes under Title VII.
RCRSN. Okay, so if Title VII laid the groundwork for anti-discrimination, the ADA built on that by asking, what about those whose very presence might require an active adjustment? This shifts us from simply not discriminating to actively accommodating, right? Which brings us to the Americans with Disabilities Act, or ADA.
That's an excellent way to frame it. The ADA, enacted in 1990 and then amended significantly in 2008.
The ADA, right.
Exactly, the ADA Amendments Act. It extends comprehensive civil rights protections to individuals with disabilities. Like Title VII, it applies to employers with 15 or more employees and strictly forbids discrimination because of a disability in all employment practices. And the definition of disability is purposefully broad: a physical or mental impairment that substantially limits a major life activity, or having a history of such an impairment, or even just being perceived as having one.
Perceived, okay.
Right. This includes episodic conditions like epilepsy or even well-controlled conditions like diabetes. It's quite broad now.
And this is where the concept of reasonable accommodation truly distinguishes the ADA. It's often the most challenging area for HR, wouldn't you say?
I would, yes, indeed. The ADA uniquely requires employers to provide reasonable accommodation to qualified individuals with disabilities, unless doing so would cause undue hardship. Now, a qualified individual is simply someone who can perform the essential functions of the job, either with or without an accommodation.
Okay.
So a deaf candidate, for instance, is qualified if she can do the job with, say, a sign language interpreter. Accommodations can range widely, from modified workstations to flexible schedules. Lots of possibilities. But the undue hardship threshold, though, that's a high bar.
Yeah.
It means significant difficulty or expense for the employer. It's not easy to claim.
So it's less about the what and more about the how. That dialogue between employer and employee is really key, isn't it? The interactive part?
Absolutely. That's the heart of it. Crucial ADA terms include essential functions, those core duties a job exists to do, and the interactive process, which is exactly that, the good faith dialogue. If an employee develops carpal tunnel, HR isn't just, telling them to cope. They're actively exploring solutions like ergonomic equipment or voice recognition software. It's a collaborative effort.
Right.
And the ADA also protects against harassment based on disability and, of course, has strong anti-retaliation provisions, just like Title VII.
What are the unique employer obligations here beyond just avoiding discrimination? This seems like a key difference from other laws.
It is a key difference. Employers must actively accommodate. That's proactive. They also have strict confidentiality rules for medical information. You can generally only collect disability-related info after a conditional job offer, with very few exceptions.
And after the offer, okay.
And you absolutely cannot ask about a disability before offering a job. These privacy rules are incredibly important under the ADA.
Makes sense. What are some common pitfalls or exam traps for the ADA that our listeners should be alert to?
Oh, definitely few. A big one. Don't confuse ADA accommodation with FMLA leave. They're related but distinct. ADA is about modifying the job or work environment. FMLA is about taking leave for specific reasons.
Different tools for different situations.
Exactly. Also, employers aren't required to provide every conceivable accommodation, or necessarily the employee's preferred one, but they must engage in that interactive process in good faith. Also remember, illegal drug use is generally not protected under the ADA.
Right.
And always keep in mind that the ADA Amendments Act of 2008 significantly broadened the definition of disability, making it easier for individuals to be covered than it was before.
Okay. For a quick memory aid, how can our listeners remember the ADA's core tenets easily?
Maybe think can do for ADA. Can the person perform essential functions? Is no accommodation needed? Or is there a duty to offer accommodation unless there's undue hardship? It kind of covers the main points. Essential functions, the accommodation duty, and the undue hardship defense.
Can do. I like that. Okay, now let's turn to a law that's all about protecting experience. The Age Discrimination in Employment Act, or ADEA. Who exactly is protected under this one?
Right, the ADEA.
Yeah.
It specifically protects workers 40 years of age and older from workplace discrimination. And here's a common exam trick. Younger employees, even if they're, say, 39, are not protected by the ADEA itself. It starts at 40.
Only 40 and up.
Correct. And covered employers are those with 20 or more employees. So a slightly different threshold than Title VII and ADA.
20 or more. Got it. So this means no discrimination in hiring, firing, pay, benefits, promotions, or layoffs for people 40 and over. But there's some interesting nuances here too, aren't there?
Definitely. Unlike Title VII, the ADEA actually allows favoring older employees over younger ones, even if both are 40 or older.
Oh, interesting.
Yeah, so if you choose a 55-year-old over a 45-year-old, even if the 45-year-old is qualified, that's generally okay under ADA. This was intended to protect older workers, perhaps from concerns about higher benefit costs. There's also a narrow BFOQ exception for age, like the historical mandatory retirement age for airline pilots, usually cited for safety reasons.
Okay.
And HR must be vigilant about job postings, avoid age preferences like young and energetic or recent grad. That's a red flag.
Absolutely. Any specific pitfalls or surprising elements to watch out for with ADEA?
Well, a common confusion is thinking age discrimination is covered by Title VII. It's got its own separate law, the ADEA.
Right, separate statute.
Exactly. Also, remember that harassment based on age, like, constantly mocking a 62-year-old for being too old to learn new tech, is also prohibited under the ADA. It's not just about hiring and firing.
Good point. And for a simple memory aid for ADA?
Super simple. ADA equals 40 or aged. Just remember that number 40 is your key threshold for protection.
40 or aged. Easy enough. Okay, leaving to something a bit more modern and maybe less familiar for some. The Genetic Information Non-Discrimination Act, or GINI. This one really looks at the future of privacy, doesn't it?
It really does. GINA is fascinating because it's so forward-looking. It prohibits employment discrimination based on genetic information. And this is broad. It includes an individual's own genetic tests or the genetic tests or family medical history of their family members.
Family history, too. Wow.
Yes. So an employer absolutely cannot use information like, say, a family history of Huntington's disease or breast cancer risk to make employment decisions like hiring, firing, or assignments.
And what are the employer's obligations regarding this incredibly sensitive information? How strict is it?
It's very strict. GINA forbids employers from requesting or requiring genetic information from employees or applicants, with only a few very, very narrow exceptions. Well, things like voluntary wellness programs, but even those have specific requirements they must meet to be compliant. GINA also strictly limits the disclosure of any genetic information that might inadvertently be obtained, like if it comes up in a conversation about FMLA, leave for a family member.
Right, you have to safeguard it.
Exactly. GINA applies to employers with 15 or more employees, same as Title VII and ED, covers all aspects of employment, and includes strong anti-retaliation provisions.
What are some key pitfalls or common missteps that HR needs to avoid with GINA? Seems easy to trip up here.
It can be. A big one is managers inadvertently, maybe innocently, gathering genetic info. If a supervisor remarks, wow, given your dad's history of heart attacks, maybe this high-stress project isn't for you, that's potentially a GINA violation right there.
Yikes, okay.
Even things like wellness questionnaires asking about family health history must be incredibly carefully structured to avoid violating GINA's rules about requesting information.
Needs careful design. And for an easy way to remember GINA.
Maybe think genes in, no action. It's a simple reminder. Genetic information shouldn't factor into employment actions or decisions. Or maybe keep your gene info normal. KGIN, GINA.
Genes in, no action. Got it. Okay, shifting gears now to a critical area for employee well-being and HR management. The Family and Medical Leave Act, or FMLA. This one often comes with its own unique set of complexities, right?
Oh, it absolutely does. The FMLA, enacted back in 1993, is a crucial right. It guarantees eligible employees up to 12 weeks of unpaid, job-protected leave for a 12-month period for specific family or medical reasons.
Okay, Unpaid and job protected are key there.
Right.
Who is covered by FMLA and what makes an employee eligible for this leave? There are several hurdles, correct?
That's where the complexity really lies, yes.
Right.
Covered employers include all public agencies, schools, and private companies with 50 or more employees within a 75-mile radius
50 within 75 miles.
during 20 or more work weeks in the current or preceding calendar year. So that's the employer test. Then an employee qualifies if they've worked for that employer for at least 12 months. They don't have to be consecutive.
Okay.
And worked at least 1,250 hours in the past 12 months. And they work at a work site where the employer has 50 or more employees within that 75-mile radius.
Wow. Okay, so all those pieces have to align.
Yes, exactly. Every single one.
And what are those specific qualifying reasons that trigger FMLA leave?
Okay, the main ones include the birth or care of a newborn child, the placement of a child for adoption or foster care, caring for an immediate family member, specifically a spouse, child, or parent with a serious health condition, or the employee's own serious health condition that prevents them from performing their essential job functions. Pregnancy and related prenatal care also fall under employee's own serious health condition.
And what counts as a serious health condition? Is that defined?
It is defined quite specifically. It generally involves inpatient care, like an overnight hospital stay or continuing treatment by a healthcare provider, which has its own sub-definitions involving incapacity plus treatment, chronic conditions, etc. And, importantly, intermittent leave, or leave on a reduced schedule, is also allowed when medically necessary for serious health conditions.
Right. And what about the employees' entitlements during and after FMLA leave? What do they get to keep and what do they return to?
Good question. Employees are entitled to continued health insurance coverage under the same terms as if they hadn't taken leave. The employer has to maintain that.
Okay, same benefits.
Right. And upon return, they must be restored to their original job or one equivalent, meaning virtually identical pay, benefits, seniority, and other terms and conditions of employment. And while FMLA leave itself is unpaid, employees can choose, or employers can actually require them, to use their accrued paid time off, like vacation or sick leave, concurrently with the FMLA leave.
Ah, so paid leave can run alongside it.
Correct. It often does.
For our SPHR learners, what's an easy formula or jingle for FMLA eligibility to keep straight on exam day?
Yeah, for eligibility, definitely engrave this little HR jingle in your mind. 12, 12, 12, 50, 50.
That's 12, 12, 12, 50, fair.
Right. That's 12 months of service, up to 12 weeks of leave, 1,250 hours worked in the prior 12 months, and 50-plus employees within 75 miles of the work site.
Yeah.
Hit all those points, and they're likely eligible.
Perfect. And just like the other laws we discussed, FMLA has its own strong anti-retaliation and interference rules, I assume?
Absolutely. Very strong. It's illegal for an employer to interfere with, restrain, or deny the exercise of any FMLA right. It's also illegal to discriminate or retaliate against anyone for opposing practices unlawful under FMLA or for participating in any FMLA proceeding.
Yeah.
This includes things like discouraging leave or using FMLA leave as a negative factor in performance reviews or promotion decisions.
So HR needs to be incredibly careful there.
Incredibly careful. Proactive training for managers is key.
What are some essential HR best practices for FMLA administration?
Okay, number one. Companies must prominently post FMLA rights information for employees. They also need to keep meticulous, accurate records of FMLA leave taken. And as I mentioned, rigorously train managers to recognize situations that might trigger FMLA, even if the employee doesn't use the magic words FMLA.
Right. Recognizing the underlying need.
Exactly. Having a clear written FMLA policy and consistently using the proper Department of Labor medical certification forms, like the WH-380 series, are also vital for consistent administration.
Makes sense. Any common pitfalls or exam traps for FMLA that you want to highlight specifically?
Yeah, definitely. Again, don't confuse FMLA leave with ADA accommodation. They can overlap, but they address different needs. FMLA is about leave for specific reasons. ADA is about modifications or accommodations for a disability.
Okay.
For example, an employee out on FMLA for pregnancy isn't automatically entitled to light duty upon return unless that light duty is an ADA accommodation for a related disability. It's a separate analysis.
Got it.
Always be precise about that serious health condition definition. Not every illness qualifies. And never, ever forget that 75-mile test for determining employer coverage and employee eligibility based on worksite. That trips up a lot of people.
That 75-mile radius seems key. Okay, we've just dissected 5 critical employment laws. When we bring them all together for our listeners studying for the SPHR, what's the unifying thread? What's the overarching principle that HR professionals must carry through all of them?
That's a great question. The single most unifying theme, I think, across Title VII, AD, 88, GINA, and FMLA is anti-retaliation.
Anti-retaliation.
Yes, every single one of these laws explicitly prohibits punishing employees for asserting their rights. Whether it's complaining about discrimination, filing a charge with the EEOC, requesting an accommodation, taking FMLA leave, or participating in an investigation. HR's fundamental mandate here is to foster a culture of no fear to report. It's absolutely non-negotiable for compliance and for building trust.
That's a powerful takeaway. Beyond the legal principles, there are some key calculations and metrics our listeners really need to be sharp on for the SPHR exam, right?
Definitely. The adverse impact ratio, using the 4/5 rule, is critical for Title VII compliance analysis.
Right. Calculate the selection rates.
Exactly. Calculate each group's selection rate, then divide the lowest rate by the highest. If that ratio dips below 0.80 or 80%, that flags potential disparate impact requiring immediate, thorough investigation. You need to know how to do that calculation. And for FMLA, as we hammered home, mastering that 12-12-12-50-50 eligibility formula is absolutely non-negotiable. You will see questions testing those thresholds.
Okay, a good reminders. Now, while our focus here is strictly U.S.-centric for the SPHR exam, it might be worth just a quick mention of the global context. Is this purely a U.S. thing?
Well, very briefly, while the specifics vary widely by country and region, many developed nations and international bodies like the International Labor Organization, ILO, and the European Union have similar underlying principles regarding anti-discrimination and workplace fairness. But for your SPHR exam, your laser focus should remain primarily on these specific U.S. federal statutes we've discussed. That's the core knowledge base being tested.
Got it. Keep it U.S. focused for the exam. All right, let's put some of this into practice. I think running through a few SPHR-style questions using the source material will really help solidify this understanding. Ready?
Let's do it. Practice is key.
Okay, let's dive into our first scenario. Question 1. Susan works at a 45-employee software firm. She's worked there for 18 months and logged 1,300 hours in the past year. Her newborn requires surgery, which is expected to take about 3 weeks of recovery time. Susan's doctor certifies that her presence at home is medically necessary during this period. Which of the following is true? Is it A, Susan is eligible for FMLA leave and her job must be protected for up to 12 weeks? B, Susan is not eligible for FMLA because her company has fewer than 50 employees. C, Susan is eligible for ADA reasonable accommodation to work from home. Or D, Susan qualifies for state short-term disability but not FMLA.
Okay, this is a classic exam trap, really designed to test all those FMLA eligibility criteria meticulously. Susan meets the tenure, 18 months is more than 12. She meets the hours, 1,300 is more than 1,250. The reason caring for a child with a serious health condition seems qualifying.
But the employer size.
Exactly. The crucial detail is the employer size. The company only has 45 employees. FMLA's threshold for private employers is 50 or more employees. So the correct answer is B. Susan is not eligible for FMLA because her employer has 45 employees, falling below that 50-employee threshold. You have to hit all the marks for FMLA eligibility.
That is a crucial detail, easy to miss if you're not careful. Okay, on to the next question. Question 2. A company requires all applicants to disclose the race of their parents on the job application form. They claim it's just for statistical tracking purposes. This practice most likely violates A, Title VII only, B, GINA only, C, Title VII and GINA D, no law because they say it's voluntary information.
Okay, this question touches on sensitive data and potentially multiple laws. Asking for applicant race information, even parental race, on an application form is risky territory. Title VII generally frowns upon asking for demographic info pre-offer because it can suggest discriminatory intent or be used improperly.
Right.
But asking for parental race specifically brings GINA into play. Parental race is essentially genetic lineage information, which falls under GINA's definition of genetic information, and GINA strictly prohibits employers from requesting genetic information from applicants. So
It hits both.
it likely hits both. The correct answer here is C. The practice probably violates both Title VII due to the risky nature of asking for race on an application, and definitely GINA, because requesting parental race is requesting genetic information.
Excellent analysis. Okay, one more to really seal the deal on understanding these nuances. Question 3. Mark is 42 years old. He's denied a promotion. The person chosen for the role is 45 years old. Mark suspects age discrimination played a role. Under the ADEA, which of the following statements is correct? A. Mark has no claim because the person promoted was also over 40. B. Mark has no claim because under ADEA, you can favor an older worker over 40, even if it disadvantages another worker who is also over 40. C. Mark can sue only if he was the absolute oldest employee considered. DMARC cannot sue under ADEA because the manager who got the job was older than him.
Okay, this question highlights that very specific, sometimes counterintuitive nuance of the ADEA we talked about. Both Mark 42 and the person promoted, 45, are within the ADEA's protected age group, 40 plus. However, the ADA specifically allows an employer to favor an older worker over a younger worker, even if both workers are 40 or older.
Ah, that's the key point.
That's the key. So
Yeah.
because the person chosen 45 is older than Mark 42, the employer's decision to favor the older candidate, even though both are protected, is permissible under the ADEA. Therefore, the correct answer is B. Mark likely has no claim under the ADEA in this specific scenario because the law allows favoring the older candidate within the protected age group.
Wow, what a fantastic deep dive into these critical U.S. employment laws for your SPHR journey. We've really unpacked Title 7, 80, ADEA, JOHN, FMLA, digging into their core protections, employer obligations, and trying to flag those sneaky exam pitfalls.
Yeah, our goal was really to simplify and reinforce these often complex topics, making sure you grasp not just the rules on paper, but the strategic implications for HR. Remember to always check those covered classes and thresholds, watch out for disallowed questions or requests for information, and critically apply the correct statute or sometimes multiple statutes to each situation. Mastering HR compliance isn't just about knowing the rules, it's truly about understanding their spirit and how they help create genuinely fair, equitable, and ultimately more successful workplaces.
Absolutely well said. This knowledge really is your superpower for building compliant, ethical, and highly effective organizations. Keep these principles in mind. Leverage those memory aids we talked about like RCRSN, Can Do, 40 or aged, genes and no action, and 12, 12, 12, 50, 50, and you'll be well on your way to mastering employment law for your SPHR and beyond. We really hope this deep dive has given you a significant advantage. Thank you so much for joining us on the deep dive.